Yes, Immigration Act 2020 became a law on 11th of November 2020, but it has received royal assent from the Queen. Immigration Act 2020 brought historical changes in immigration law from last 50 years. It ended free movement of EU nationals and their family member, and also it introduced new point-based immigration system for EU nationals as well as non-EU nationals. In this video, I'll speak some important point which brought by this Immigration Act 2020 for the UK immigration system. That is how it ends and how it will affect EU citizen and their family member. I'll also give an update about the new primary system, what it's going to introduce by the Immigration Act 2020. This session is for live question and answer session. If you have any question, please feel free to leave a comment and I'll give your answer the live session. Please don't give any, if you think this is a confidential, you don't write any comment. Alternatively, you can send me an email or a message and I'll give your answer by email. Stay with me and enjoy the show. Welcome back, viewers. The Immigration Act 2020 first introduction, what is update is in terms of Irish citizen. Irish citizen also EU nationals, and they can exercise both EU law and they have a special status under the as a EU Irish citizen. However, in Immigration Act 2020, in terms of Irish citizen, that all Irish citizen doesn't require to live to enter or remain in the United Kingdom unless subsection 2, 3, or 4 apply to that citizen. It means that Irish citizen right now, they can exercise EU law. However, as under the EU settlement scheme or the EU withdrawal agreement, EU nationals will not be able to continue to live in the UK after Brexit unless they have a settled status. Irish citizen also EU citizen. However, in Immigration Act 2020 introduced, yes, all the EU nationals and their family member will be required to apply for settled or pre-settled status. However, Irish citizen, it doesn't require because they have a special relationship, they have a special position in the UK, therefore they doesn't require. But this is what they say. But I'll advise, or I think it will be a good decision to apply for pre-settled status under the EU law, because under the EU settlement scheme, because EU settlement scheme is more flexible than the Irish, what the arrangement have with the UK. Other than Irish citizen, it has ended the free movement from 31st December 2020. So most of the EU citizen and my viewers, followers know about it, that from 31st of December 2020, this is the deadline for Brexit, transitional period. So if any EU nationals want to come to the UK, they must come before 31st December 2020. There has to be established that before the date a qualified person. And if they want to invite their family member, also they can invite under the EU settlement scheme. This is the deadline for free movement, but for application for settled status or pre-settled status, the deadline is 31st of June 2020. Now, those EU nationals who will be in the UK before 31st December, they can make the application until June 2021. Now, in terms of family members, if they want to invite their family member, they can invite even after 31st of December, 31st of June 2022 until 31st of December 2025. This is what for EU nationals. Now, many people face this issue, and I find even a couple of my clients that the EU family member, including dependent parents. Now, many Home Office refuse many applications for EU nationals who want to bring their parents from outside the EU, outside the UK, on the ground that Home Office are saying on the refusal letter that your parents is not dependent on EU. Now, what is the position, legal position of parents under the EU law? Under the EU law, parents, dependent parents, what I said is a family member under EU Regulation 7. At the same time, under the EU settlement scheme, they are also family member, close family members. Now, many people have confusion. The word it's a dependent. Yes, the law requires that you are a dependent parent has to be dependent, but also law assume that parents are dependent on EU national. You don't need to provide any evidence that they are dependent. Although we encourage for EU national to provide your proof of that your parents are dependent on you, that is, you send money regularly. However, it is not a mandatory document if the Home Office refuse on the ground that they are not satisfied that your parents are dependent on you because you fail to provide proof of dependency, that you don't send them regularly money or bank statement or some other ground. You can challenge this decision because this is unreasonable. Because if you look at the policy guidelines of EU settlement scheme, where the definition is a close family member, parents, dependent parents, is clearly said that the law, it is assumed that parents are dependent and the sponsor doesn't require to provide any evidence. I know many applications and are now refused by the Home Office on the ground that they don't believe that the parents, EU parents, are dependent on EU nationals. On that ground, I find many questions on Facebook as well as they call my office. But you can challenge this and have a look, read the EU settlement guidelines, because you can argue with the Home Office. Well, law assume that it's clearly said, law assume that parents are dependent on EU nationals and on their children, and it say clearly the second line, the EU sponsor doesn't require to provide evidence that their parents are dependent on them. So it is important for EU nationals. Maybe it will be helpful, and you can find this information on EU settlement scheme guidelines, as well as in many case law in European case law. However, after the Brexit, after 31st December 2020, the dependency you have to prove. So if you apply after December for your parents, because you can apply for your family member to bring in the UK under EU settlement scheme until 2025. If you satisfy certain requirement, that is, you must be a qualified person, you must be in the UK before 31st December 2020, you have to, your relationship must be started before Brexit, and your relationship was continue until the day of application. So if you satisfy this requirement, you can make the application to invite your family member to come to the UK even after Brexit. However, after Brexit, the law will not assume that your parent is dependent. You need to prove that your parents are dependent. Now, the level of dependency is very important. You must provide evidence that your parents is fully dependent on you. They don't have any income on their home country, and you need to send that amount of money, which is required according to the economic circumstance of your home country. If you just send £20 or £30, it will not make sense that your parents depend on you. So you can assume, for example, if you look at, take an example for Bangladesh, so 20,000 taka or 30,000 or 40,000 taka is sufficient. So you can send 300 to 400 pounds per month for your family, for your parents, and then you can claim their yes, dependent. This is sufficient evidence. So that's what you have to prove after Brexit. So this is about free movement of the Immigration Act 2020, which will end free movement, and now it became law because the Queen gave her consent, and accordingly it introduced the restriction for EU nationals. Then after Brexit, they will not be able to come to the UK under free movement. The second important introduced that the Immigration Act 2020 also introduced the new point-based system. What we and the lawyer and a lot of people are giving update continuously from couple of months. That is, they are saying that new work permit is coming from January 22. And although I said this is not correct, work permit never was closed, always it open. Yes, it is it bit flexible now than compared to previous work permit system. So new Immigration Act 2020, what became law last week, 11th of November, this week, 11th of November 2020, after Queen gave her consent. Now it introduced new point-based work permit system. So if anyone eligible under the new work permit point-based system, he will get visa to come to the UK. Now, what is the question? What is the eligibility? Very straightforward answer. The eligibility requirement for a new point-based system is £70. I'll explain how someone can achieve £70 and what you should do right now if you want to get a work permit visa right now to come to the UK. I'll give some tips. It will not be an advice. It will be some information and tips which might helpful for you or for your family member to get a visa for work permit in the UK in future. Stay with me. I'll come after a short break. Yes, so under the new point-based system, the requirement is you must get 70 points. Now the 70 point will come from different sources. So Home Office introduced a structure that is 50 point is mandatory for every applicant. This 50 point you will get from 3 different sources. So altogether you need 70 point. I'll tell you how you will get 70 point, but before that, I'll give you some important tips to get a work permit visa in the UK. First of all, you have to be very careful because the way some people become active in social media, in YouTube, in different platforms, that is, they're saying that student visa and work permit is going to open from next January, and they're inviting people for take this advantage to come to the UK. In my opinion, this information is not correct. First of all, work permit never been stopped, never been closed in the UK. It was before. Right now, work permit is open, and it will be open in January again. It will keep open. It will continue to open from January as well. Student visa also never closed in the UK. From my century of experience, I saw student visa was open, never it been closed, and it will be open. From time to time, the Home Office introduced different rules, reform the immigration system. As a part of reform, Home Office introduced some reform again in the new immigration rules. However, what I can say, yes, there is a flexibility in the immigration work permit new point-based system. That is, for example, labor market test. The employer doesn't need to provide evidence of that no one available from the UK to get the work permit to fill up the vacancy. That what has been removed. In terms of the flexibility, what I come now, Immigration Act 2020 introduced again the eligibility requirement for work permit, which is point-based system. Now, an applicant who will get a sponsor from the first sponsorship, he will get 20 points. First 50 point is mandatory for everyone, and then the next of 20 point is optional. So optional means you have an option to pick next 20 point from different area, different category. So first, if you get a sponsorship from any UK company, which is a registered company, a registered sponsorship, you will get 20 points. If your job at appropriate skill level, you will get 20 points. Now, appropriate skill level means level 3. which is lower than the previous work permit point-based system. Under the previous work permit, the appropriate skill level was level 6, which is very tough. Normally, engineer, doctor, more skill, high skill people can come to the UK, but existing level is very low. So these types of people, basically baker, electrician, plumber, butcher, so minimum level of skill level job people can come to the UK. But remember, not for unskilled, those who doesn't have any skill, they will not able to come under the new point-based system. You must have some form of skill, and the Home Office will introduce a list of skill jobs in the immigration rules soon before January, and then your skill has to be on that level. Now, if you just, for example, chef or tandoori chef or a restaurant manager, if you just claim I'm a chef, the Home Office will interview you, and then they will find out whether you genuinely have that skill. So the way some people are telling in different media that new point-based system is flexible, new point-based system introduced that, the new point-based system is more easier, and you can come, a student can bring as much as people they can. It's not correct. Trust me. Home Office and the UK will not open their door for the people come from Bangladesh or anywhere. This is, I think this is not the right information some people are giving. So you have to be very careful. Look at now in UK, those people who are watching my video, probably you are familiar. How many people losing their job? How many people are losing their job? People in UK citizen, they don't have job right now. And how they will hire from overseas from January to fill up a vacancy. Right now, 4.8% unemployment rise due to the COVID. And think about after January and after the lockdown period, what the economic situation will be in the UK. So it is, I'm not sure how these people, and they are very qualified people, more qualified than me, are people inviting people to come to the UK under new point-based system. So this is not a right information. I think that yes, it is flexible, but the way it is now presented to the audience, this is not how the EU people can come, because this is a skill job. Because this work tier 2 work permit, what used to be previous existing system, now it said it changed to skill job. Now, skilled worker. So you have to be a skilled worker if you want to come to the UK under new point-based system. So, for example, if you are a carpenter in work in Bangladesh or India, or if you are a butcher or if you are a baker, or if you are an electrician, if you are a genuine chef, that you can come to the UK under new point-based system. Yes, that it is helpful for you. But especially from Bangladesh, especially from my district, from Sylhet, I know many people they don't do anything. They are ready to their money going from London or somewhere, and they don't, for example, they finish their study, intermediate or some or honors, and then waiting to come London. You don't have any skill. This work permit is not for you, brother. This work permit for skilled people. Those who have a skill, they can come in this way. So what I'll go back to my discussion again, that is 50 point, sponsorship 20 point. If your job at appropriate skill level, you'll get 20 point. And if you can speak English, you'll get 10 point. This 50 point is mandatory for every applicant. So where our brother who want to come to the UK from Bangladesh or India, they will quote on skill level job, because most of the people that don't have that skill to come to the UK, and this work permit is point-based system, and you'll get 20 points from the skill, from the job that your job at a skill level job, and this is mandatory. If you don't have that skill, you'll not able to come to the UK under the new point-based system. So if you get 50 points, you have that skill, then you need 20 points more. Now that 20 points you will get from different criteria. For example, if your job offer, the wages but salary of your job offer is 25,600 pounds, you'll get 20 points. Majority people will satisfy the 20 points from that category, that is salary requirement. So if you get 20 points from your salary, that is if the employer offer you 25,600 pounds, you will get 70 points. I'll give an example from, for example, a restaurant who want to hire a chef from Bangladesh. Now, the first things, this restaurant has to be obtained a sponsor license from the Home Office. If you don't have license from the Home Office, the restaurant will not able to offer a job or hire a person from Bangladesh. Now, thousands of restaurants in the UK. But not many restaurants have that sponsor license. So first thing, what you have to do, the restaurant should do, they should apply for restaurant. Now, many people contacted in my office. They send me email. They have a takeaway. They have a restaurant. They have a small. Now, will they able to hire someone from Bangladesh to bring here? Unfortunately, not this type of business able to invite people from Bangladesh. First, they don't have sponsor license. Now, you need to apply for a sponsor license, and probably you are familiar with how the sponsor license work, because once you apply the Home Office, the Home Office law, of course, they will not just issue a sponsor license. They will check whether you are eligible or not, so that they have that you cannot abuse the process. You cannot misuse the work permit system, the appointment system. So maybe they will see, well, how many people are working in your business right now, how much they are getting salary. Now you are not showing how much you are earning, you are not paying tax to the government. Now, if you don't have enough, now you are paying 10,000 or 8,000 pound salary right now for last 5 years for your worker. How will you pay 25,000 for a new person? So this is the question. So many businesses will not able to invite the people. However, some businesses who have a good track record, they can invite and hire people from a chef from overseas. So first need a license from the Home Office, and then let's go to the people who want to come. So if any applicant want to come to the UK, you need a cast letter from you need a letter from, that is what a sponsor letter from your employer, from restaurant, and then you need that level of skill. For example, you are a chef, so you need to provide evidence to the Home Office that you are a chef. Now, if you provided evidence, Home Office will interview. Home Office take an interview to you, contact with you, what skill you have, and you need to pass the interview. Home Office will speak with you in English because you have that level of English, B1 level. So once you satisfy that you are a genuine worker, you have the genuine skill, then you will get visa. Now, the way we are hoping is not the case. The reality is different. So what you have to do now, if you have a brother or if you have a relatives who have a restaurant, who have a business in the UK right now, you start learning English. You want to pass B110 English language test, and then you can get some training from that skill. For example, most of the Bangladeshi community will come in restaurant sector. So if you want to come on restaurant as a worker, as a chef, you should do some sort of training. You should gain some sort of skill from your own country, and then you can tell the Home Office and then employer that I have that level of skill, and then you can come under the new work permit system. Now, other than the salary requirement, I said the salary, which is 25,600 pound, you will get 20 points. There are also some criteria where if your job is at a shortage occupation list, in the Home Office right now, Appendix K, there is a shortage occupation list. If your job on that list, you will get automatically 20 points. If you have a PhD degree, or if you do come for a job which is at PhD level on a STEM subject, means science, technology, medical science, engineering, that type of subject, PhD, you will get another 20 points. So this is the area where you can get 20 points. So this 70 point is mandatory for everyone, and once you satisfy the 70 point, you are eligible. Now, you satisfy the eligibility requirement, you will get visa. Still something left. Okay, so if you still want to come under the new point-based system, you should satisfy the financial maintenance requirement, which is you must have 1,270 pounds for per month, which is if you come to the UK, you must have this money, 1,270 pounds for 28 days in your bank account. This is what we call finance maintenance requirement. You must have that money. Although you will not get any point from maintenance, it used to be under the existing Tier 2 general work permit. That is, you will get 10 points from maintenance, but right under the new work permit system, you will not get any point. However, still you need to satisfy that you have a maintenance in your bank account, and the amount is 1,270 pounds. Period of grant, how long you will get visa under the new point-based system work permit. Well, the that the, under the existing tier 2 general work permit, a person can get or stay in the UK up to 6 years under the new under the existing tier 2 general work permit. However, the new point-based system allow to stay longer than 6 years, means unlimited extension, and also there is no cooling off period. Cooling off period means if you, for example, in ICT tier 2 visa, you need to, once your visa expires, you need to go back to your home country and you need to stay 12 months. After 1 year, you can come back to the UK. That is what's cooling off period. You cannot switch in the UK, nor you can go back to your home country and then apply again. So this is what the cooling off period work. But under the new point-based system, again, there is no cooling off period. Now, this is another important settlement. Yes, you can apply for settlement after 5 years. Now, also, this is an important changes under the salary requirement, because under the existing tier 2 general work permit, if anyone want to apply for indefinite leave to remain, the salary has to be 35,800 pounds. If your salary is not 35,800 pounds under the tier 2 general work permit, you will not able to apply for ILR, indefinite leave to remain, despite you already completed 5 years. However, under the new point-based system, the salary requirement is 25,600 pounds. So as soon as you satisfy this requirement, you can apply for ILR. So these are the changes. Other than this, I already spoke about a labor market test that what introduced under the new point-based system. Then student visa, again, also under the Immigration Act 2020, introduced post-study work permit for the international student. I'll give a brief update about student visa. There are many people giving a lot of information about student visa. Unfortunately, some wrong information coming on the market as well. So you have to be very careful not to misguide someone, so that you can get correct information. I'll give you some brief information about student visa after a short break. So, student visa. Student visa. Immigration Act 2020 became a law because on 11th of November, after Queen gave her consent, so it became a law now. So it introduced many historical changes. I think the Immigration Act 2020 introduced a lot of new rules for work permit, for ending free movement of EU nationals and their family member, and also introduce new immigration rules for international students. So first introduction, what I said, that immigration rules gave a 2-year post-study work permit for international students. Other than this, I will say nothing, not a major changes come. The main changes is international, that is post-study work permit, which if any international student from next year complete a course or graduate from the UK from either honors or a master's, he will or she will get 2 years work permit. Now, the question is, what are the changes come? Actually, I will say not any other changes come. What they did, actually, the Home Office introduced a new appendix, which is Appendix ST. It was used to be in immigration rules before, the rules or policy relating to the international student. It was in immigration rules, however, in Part 6. But now Home Office just move the immigration rules in Appendix ST, and just in plain English, I'll say is yes, a little bit clear, because immigration rules is very complex and confusing. And the existing rules for a student, they move in Appendix ST, but the that the rules is same. Still, the international student can work 20 hours while they are they start with the course during their study when they are in university. During the vacation period, they can work full time. Internal student who doing postgraduate, they can bring their dependent. Internal student who are in the UK, they have to comply all the immigration rules. So the rules are same. The English language requirement, which is they have to pass, if they do any undergraduate course, they have to pass B1 over a graduate course, or master, so they have to do B2. So these are the changes what come. Not many changes. Again, the maintenance, which is again changes. So maintenance and increase. They have to again gain 70 points from different source. From cost letter, they will get from cost, which is from university that is sponsored from university. The letter, they will get 50 points. They will get 10 points from their my maintenance financial requirement. They have to keep that money in their bank account. They have to satisfy English language requirement. Again, they'll get 10 points, so total 70 points. This was used to be before and right now. So in terms of student immigration rules, not many changes come. So that is what. Let me take some question, and then I'll back to give some important update about TOEIC, because this week important case came. I'll give you relating to a TOEIC case, and it was actually a case where the Home Office revoked the indefinite leave to remain of an applicant who the Home Office had an allegation against him to use TOEIC certificate previously. This case was judgment came this week, so I'll give you an update today. But before that, I'll take some questions. So, one brother, Jamal Ansari, hello sir. My question is: I had my interview 11 November. I want to know how long it take to answer. Thank you. Thank you, brother Jamal Ansari. I appreciate for your question. Yes, right now the result is a bit delayed, not only the interview, but you are lucky at least you had an interview, but because due to the pandemic, most of the interview was suspended. However, you did, so probably 2 months, around 2 months, 8 weeks, normally decision will come. And unless the lockdown or any expected circumstance. So I think you need to wait, brother, at least 8 weeks, and then let's see. Good luck, Mr. Jamal Sani. Nice to hear that you had an interview. And then next question, Abi Ahad, spouse visa extension. I don't know what is your question is. If you clear your question, I am happy to give you an answer. Also, I will give some answer because I have received plenty of email. So from there, I'll give someone asked me, I'll not mention the name because it's a confidential name. My wife is a British born, and also I have 4-year-old daughter, which is also a British citizen by birth. I'm a bit confused about pre-settlement as I'm holding EFM 5 years, which is going to be, and I'm on Surinder Singh case route. Yeah, this is very important, I think, question for many people, because Surinder Singh case, the route will be closed from 31st December 2020. So if you want to come for any British citizen who are living in Europe, and if you bring your family member from Bangladesh or anywhere, and if you want to come back to the UK, you should come before 31st December 2020, because Surinder Singh route will close from 31st December 2020. This is very important because a lot of British citizens who cannot bring their family from overseas in the UK due to the strict requirement, immigration rules, because if anyone want to invite their family member, they need to satisfy lots of requirements under the UK immigration rules. However, EU law is more easier. So what the many people do, they move to any European country and bring their family. And then there is a case law, which is Surinder Singh case. Then the British citizen can come to the UK with their non-EU family member under the EU law, which is a case law, which is Surinder Singh case. So this route will close from 31st of December. So if you want to apply for this route, or if you want to come to the UK, back to the UK with your non-EU family member under the EU law, you should come before December, 31st December 2020. And the next question. Is it true that obtaining a CAS for student visa will guarantee visa approval? Because I was in the UK before, but I was overstayed and back to Pakistan. Thank you very much. This is not true that that CAS letter will give you a guarantee to get visa. Because immigration rules, what the Home Office introduced last month in Appendix ST, that is, you must be satisfied that you are a genuine student. So now, how the Home Office will introduce that you are a genuine student? That's what the Home Office policy is. You must the Home Office will interview you, and then they will ask question about your background, about your future plan, about your the course, why you want to go to UK, and then if the Home Office satisfied that you are a genuine student, then you will get visa. So CAS will not give you a guarantee. Next question. Dear brother, I applied for a visa, a spouse visa, but when I make an application in the form, I did a mistake. After submission, I have noticed and I cannot amend it. Can you tell me what I can do? These types of issue, I think now already you have submit and you make the payment, you cannot change anything. So what you can do when you will submit or upload your document, you can submit a statutory declaration mentioning that what mistake you did in the application form and what should be the correct answer. That's what you should do. Jamal Ansari, you asked me, I got right to work. Can I apply for provisional license, please? Yes, you can apply for a license, for driving license to the UK. There, as you have right to work and probably you have a temporary leave to remain. You don't need to only should right to work. Even if you have the temporary leave to remain as a refugee, you can apply for driving license. Next question. I'm a non-EU national holding 5 years Spanish residence card, clearly said as a family member of EU citizen, although we are civil partner, not married. We both arrived in October 2019. First, my spouse applied for EU settlement scheme, and then I applied for. The Home Office refused that I am not a family member. Thank you very much for your question. I think the issue is when you make the application, did you make an application as a family members? Because family members means spouse, civil partner, children, dependent parents. These group are children is under 21 years old. If they're over 21, they have to prove they're dependent on the parents. Now you have to ask this question because you are not a family member, rather than you could think you are an extended family member. So although the Home Office accept some exceptional circumstance where your relationship is last more than 2 years and akin to marriage, but not obviously not a marriage of convenience. So that have to be looked at into. I think, as you said, you have. I don't know. You didn't mention whether you have any child as you are living with your partner. Then in that case, you can make an appeal and then explain your situation or provide some more evidence that you are keen to marry, you are in genuine relationship, and on the basis of your relationship, which is more than 2 years, that's what you need to be proof to satisfy the Home Office that you have a genuine relationship. Next question. Dear brother, I want to apply for Tier 4 student visa. I'm getting my bank statement for visa approval. I have a required amount, 3 separate bank account, $1 account, 1 dirham, and 1 PKR account. To obtain the visa, is it necessary to show the money in one bank account? Can I submit all 3 bank statements? Thank you for your question. It is not necessary that all the maintenance money has to be one bank account. It can be 2 different bank accounts or 3 different bank accounts, as soon as you have that amount of money, which is 1,265 pounds for per month, and you need to keep that money for 9 months in your bank account for 28 days. That's what the requirement is. Now, if you have $1 account, 1 dirham account, 1 PKR, Pakistani probably rupee, this is a question will be for the Home Office. Why use 3 different bank account, $1? This is seems to confusing, but the law you satisfy the legal requirement. If you have money, even needs to do 3 different bank accounts. So your question is, yes, you satisfy the requirement, so it will not be an issue. Next question. I went to UK 2010 as a student. I stayed there until 2016, but I overstayed there for 4 years. Now I am in Spain. I have a temporary residence card for Spain. Can I apply for British visit visa from UK to Spain? You can apply for visit visa to come to the UK, although Home Office may consider, even in the application form, you need to give the information where you've been in the UK. So Home Office may consider your immigration history, and if they find in their system that your immigration history was not good enough, in that case they will refuse your application. But you can. Your question is, can I apply? Yes, you can apply. But Home Office may consider your background. Next question. I need your valuable advice, sir. I actually came into the UK in 2010. Last month, 31st October, my ILR was approved. My daughter is when my wife. Unfortunately, I cannot go through because it's too long question. Hello, sir. Can you answer me my question, please? My dad come from India for my uncle funeral. Do he need to be in quarantine for 14 days? Yes. Your answer is yes. Also, it's not a immigration question, but I'll give you answer. Yes, sir. My wife spouse visa due for renewal of January. Could you please guide me to which application form I should use? Thank you for your question. The application FLRFP, you need to there is no more paper form. You need to make the application online. So if you go to the Home Office Family Visa Extension section, there is a form called FLRFP. You need to make this application used to, if you, as you said, you want to make the application on 10-year route. So this is all about today. I hope today information will help some of you. But before that, what I said that I want to give you important update about TOEIC, because this week one of the important case decided by the upper tribunal. TOEIC, probably many of you know that a lot of students became victim of the scam. Home Secretary Theresa May, she was one of the Home Secretary who wrongly deported many international students. Many their visa was withdrawn. Accordingly, one of the students whose name is Mr. are his are the this what happened to him. His ILR was withdrawn. Home Office suspend his indefinite leave to remain on the ground of fraud. That is, the Home Office allegation is he used TOEIC certificate to get ILR in the UK. So this case went to the upper tribunal, and the judgment card. The upper tribunal allowed the judicial review claim in Mir versus Secretary of State for the Home Department, challenging the Home Secretary decision to revoke applicants indefinite leave to remain on the ground that he had obtained that leave by relying on a fraudulent English language certificate. The upper tribunal held that the Home Secretary decision was unlawful because in revoking the applicant indefinite leave to remain, she failed to exercise her statutory discretion and to act according to with her published policy. The upper tribunal also held that Home Secretary acted unfairly in revoking the applicant's indefinite leave to remain without putting him on a notice as to allegation of fraud. The upper tribunal accordingly allowed the judicial review claim and quashed the Home Office decision. Many students, many people lost their indefinite leave to remain. And I think have a look this case. If you have any issue with TOEIC, this case also discuss a lot of issue, a lot of policy, and it is an upper tribunal decision. The case is called Mir R versus Secretary of State. It was published 13 October 2020. The decision come 30 October 2020 and published later. So have a look for if you have any issue with TOEIC. Thank you all of you today, and I'll finish my live session. I'll come tomorrow again to speak in Bengali for my Bangladeshi followers. In the meantime, stay well, be safe, and see you later.